Texas's controversial abortion ban will stand for now. So says the Supreme Court in this 7-page order released just this morning. But the High Court also says they will expedite a hearing on the legalities surrounding the law. And I'm talking about fast. Oral arguments will take place in just 10 days. But here's what's interesting. The High Court will not directly consider whether the substance of the Texas abortion law is legal. Instead, the justices will answer 2 questions. Number 1, whether Texas's unusual enforcement mechanism that allows private citizens to civilly sue constitutionally protected rights like abortion and by default insulating the state of Texas from federal court review, whether that's legal or not. And the second is whether the Department of Justice has the right to sue or block this state law. It's important to note, as this case moves through the Supreme Court process, the justices have also said that law can remain in effect in Texas, and there's no time frame for when the decision will be made. Oral arguments will begin on Monday, November 1st. And keep in mind, the Supreme Court is also hearing another abortion case out of Mississippi. That case starts on December 1st.
If a COVID-19 vaccine is required by your employer and you refuse and you get fired, can you qualify for unemployment benefits? And whatever happened to the president's order that companies with more than 100 employees have to either have a vaccine mandate or submit to rigorous testing requirements? Whatever happened to that? Both valid questions. And before I get to the answers, let me just say the Supreme Court has repeatedly upheld state and private business vaccine mandates as legal, both over the years and 3 times so far in 2021. So let me answer your questions. First, if you're fired for refusing the COVID-19 vaccine as a term of your employment, can you collect unemployment benefits? Every state is different, but generally, no. However, there are some loopholes. Workers typically qualify for unemployment benefits if they are terminated through no fault of their own. But experts say they forfeit their unemployment benefits if they either leave a position on their own volition or if they are terminated for cause, such as because they failed to comply with a company policy like a vaccine mandate. Again, every state takes a different stance on employment vaccine mandates and how to handle terminations as a result of non-compliance. Fired employees, in some cases but not all, can challenge the unemployment benefit denial if your employer does not have a formal COVID-19 vaccine policy that you've been made aware of, or if your employer refuses your medical or religious exemption because it cannot be reasonably accommodated, and the state unemployment office finds that you in fact do have a valid excuse. Now, that might not always work though, because your employer can legally deny your exemption and then you can legally be denied unemployment benefits. So many states handle these issues on a case-by-case basis, so it's up to you to check with your state's unemployment regulations. Now to the second question. What happened to the president's vaccine mandate or rigorous testing requirement for private companies with more than 100 employees? Well, as I told you when the announcement was made in this video, it's up to the Labor Department and OSHA to come up with the actual policy and language and then distribute that to the states. Since that announcement was made, the Labor Department has been meeting with lobbyists from more than 40 labor unions and groups opposed to the vaccine mandates and other interested parties. No official timeline has been given for when the OSHA and Labor Department rules will be made public, but some private companies have already implemented their own vaccine or testing mandates ahead of the Labor Department rules, and as long as it doesn't violate a state rule, it's totally their right to do so.